We're talking to Samantha Dewester. She was the attorney in the case. So, Sam, your thoughts on what happened today for your side?
I think the evidence speaks for itself. My client, Alexandra Wilson, did not have a felony, nor has ever had a felony, and comports with the state statutes to run for office. And it's now since been expunged, so it's kind of just a moot point now.
One thing that Mr. Bob had said was the fact that she was convicted. She pled guilty to a felony, and once she pled guilty, whatever happened afterwards, it didn't really matter. She pled guilty to a felony, so therefore she can't be on the ballot.
Yeah, that's false. Not one single document. I know he wants to say that it does, but he's never done criminal law to my knowledge. I've done criminal law. The judge just explained that he has sat in that court doing. You can't simultaneously plead to the two different charges at once under one count. So it said D felony, but also a miss. The statute under Title III, it says conviction of a crime where the convicted person would be in prison for longer than 365 days. There is not a single other misdemeanor is what they're referring to without saying it. So it's just patently false what they're doing. I mean, it's unfortunate, but whatever.
Go ahead.
Is this something that you think the legislature will need to go back and clarify?
I'm guessing because of this case, they'll clarify it.
And what would be the clarification then? What would the language be that you insert that would make this clear?
Guessing it's the a misdemeanor up front, right? I know Mr. Bob, or his client, was trying to make the argument that, it doesn't say. Well, I don't know if I've ever reviewed a plea that says you're pleading guilty to this. I mean, it's just a charge. It's a boilerplate. That was a checkbox handwritten document from 15 years ago that says what the charge was. There's no lesser included, but we're making it a misdemeanor today, and here's your sentence today. It doesn't need or require some proclamation from the prosecutor that we are going to acknowledge the AMS statute. We all know that, right? When you're in a criminal case, when you're in court, you know what AMS is.
Explain AMS for our audience who may not know it.
Alternative misdemeanor sentencing. So under the statute, thank you, certain crimes allow you to plead to an a misdemeanor, and there's felony levels that if someone does it, like my client had zero on her criminal record, then they allow you, the prosecutor, it's the decision's up to them. Or sometimes they plead open to the court and the judge will say, nope, I'll accept your plea today and I'm making it a misdemeanor today. So you can plead open, or it's via plea agreement. Hers is via plea agreement that under the alternative misdemeanor sentencing statutes, that instead of having a felony tagged to your record, which can disqualify you from lots of things that we all know, we'll make it a misdemeanor because you have nothing prior. Now, they could have also made the decision that we're going to, sentence you to 100, or 545 days, year and a half probation, and then we'll make it a misdemeanor on the back end, which is AMS on the back end. If you successfully complete probation in all the classes and pay your fines, then we'll make it a misdemeanor. That was not done in this case. It was done up front. So that's the difference. And I said it at the commission hearing as well. Let me explain to you what AMS is up front or on the back, and that's what it is.
What about, I guess the question is, it seemed like there was enough for a layperson sort of watching this, confusion on the misdemeanor versus felony part, that the judge, it's like baseball, a tie goes to the runner, that there's so much confusion that to take her off the ballot would disenfranchise voters, plus the primaries are 2 weeks away and some change, that the court would come back like, hey, she stays on the ballot, but legislature, you really need to fix this and clear this up.
Yeah, to me it's not that unclear. They've made it seem unclear with all the gobbledygook and opinions of an AG from 20 years ago, no offense, Mr. Carter, or annotated codes and whatnot. It's pretty clear that Title III says we define it as this, and so you should just stop. You don't need to go beyond that. But if the General Assembly wants to make it clear, they certainly can weigh in. I know there were people from the General Assembly that were watching the State Election Commission hearing, and I'm guessing they will clear it up, because there's no way they intended for someone convicted of a misdemeanor to not be able to run, because, let's be honest, some people in the General Assembly wouldn't be able to run, right?
Has the statute been changed since 2010? So there's no question that we're dealing, is it the old statute or new statute in this case, because the statute was static since 2010, right?
It's by what is now. Okay. Even though there were some things that were done then, it's what is up to date now. Okay. And it's just I don't know. It just seems like a waste of time and, utter nonsense to keep arguing that there was a felony. There's not. I can show you pleas that are blatant felonies that are, this is a conviction of a felony and we'll reduce it. I mean, because the language is clear in those pleas. And I think the judge alluded to, I sat in this judge's court. I've seen pleas. I've done criminal. Any criminal attorney knows what that means. Like what she pled to and what the check boxes mean, right? Those are just forms. They probably have them in the dozens in a courtroom, right? 15 years ago.
So the forms could not be adjusted to the nuances of this case?
No, they're literally just check boxes. Mm-hmm. It's just a Xerox copy, and, courtrooms will keep them, deputy prosecutors will grab them, check, type thing.
Something I thought was interesting, like I said, for the folks playing at home, this gets a little bit in the lawyer weeds, so bear with me for a second here, about service of process. You said you weren't served,
that's right.
Your client wasn't served,
that's right.
And no one was served
that's right.
at all. Why is that a big deal? Why is it important? Once again, for the folks playing at home who may not necessarily know how the law works.
Okay, because you are entitled to be put on notice when anything, anyone or anything involves you as a party to a case. A request for judicial review, petition for judicial review, has parties that need to be served, right? So anybody, it doesn't matter that there was an underlying thing, right? It's whoever was party to that, they can hire new counsel, whatever, but the parties must be served. The 4 members of the State Election Commission certainly deserve to be put on notice about something pending that's challenging their decision, whatever. I could technically depose all 4 members. I could depose all kinds of people. I could depose his client. The trial rules still matter and they are applicable here. So your client has a right to be put on notice. She should have been named and she should have been served, still has not, because the AOPA is very clear on that, but also the Election Commission via the attorney. I mean, there's clear, under Trial Rule 4 in AOPA, it's clear how you serve people. It's the head of the agency, it would be, I'm presuming, Beth Boyce, who is the head of the State Election Commission, and the AG, who represents state agencies. There's not even a summons filed in the system. So, they aren't the trial rules according to Jim Bob. They are just the Indiana trial rules, and it is litigation 101. There's not even an appearance on file. I don't even know what that means, but somehow the Attorney General's office knew to file a responsive pleading or an appearance a day later without having a summons. So there's that.
You've been clear what you think Mr. Bob's handling of this case is. What do you think about the attorney generals in this case? They were seemed to be on the fence. Well, we could see how the statute could be read either way.
Yep. Well, they need to talk to their client because that's who they're representing. And they're not representing me. I can disagree what they're saying, but that just confused me with, in law, you either do or you don't. It's like when you're pregnant. You either are or you aren't, right? You either defend your client and you say what needs to be said. It's not, well, I could see today now that I've had a moment to reflect. No. You deal with it, right? Read the statutes, right? Say something. Do something. I mean, we just about allowed 3 counties to have people disenfranchised last week for no reason that are not parties. Again, it goes right back to the rules of trial procedure. It is very, very simple. You can't just do that. You can't issue a preliminary injunction when you've not put anybody on notice because they have a chance to respond. Anybody has a chance to respond.
It seemed from sort of watching in there, watching you and Mr. Bob kind of butt heads a little bit. It seemed like you were Godzilla and King Kong, and the Attorney General's office was a little Japanese city in the middle.
Well, I don't know about that. I did.
Hey, it's me. Come on.
Yeah, well, I know that that office has a lot of younger attorneys. Those guys seem just fine. But again, they have a client to protect, and so do I, and so does Mr. Bob. But again, I would be talking to the Election Commission, one of the members of which was here. I would want to know if I was a member. What's going on? Why didn't you respond to something last week? Or how did you know about all this when you haven't been served? We haven't been served. Do we have copies of anything? Because, like I said, I can choose to file a notice of deposition and start deposing all kinds of people and doing other stuff. It's a civil case. Just because Title III is attached to it or election, which is the election code, doesn't mean that it's some mutant type of litigation that we suspend the rules of evidence and trial procedure because of it. It's not. There's nothing in code that says you need to expedite all of this right now, hearings in 2 days, silliness. That it's a civil case. You have defamation stuff going on. It is no different than that except for the subject matter content. That's it.
Final question. What should people take away from this, hearing this whole process? Like I said, regular people who just want to go and vote.
Go and vote? Well, I'd be informed of who you're voting for, and the fact that about 3 counties just got disenfranchised last week. But having said that, I'd be concerned if, people on their criminal record, if they have any type of something that can be expunged, go get it expunged. Go to the Supreme Court's website, which is what my client did, easy breezy, filled it out because it's a misdemeanor from 15 years ago, easy breezy. But you can do it. You don't need to necessarily hire an attorney. Might help, but not everybody knows they can do that. And not everybody knows that when they run for office, they need to do all of this stuff, right? It's all new to people, and Title III is a very strange animal.
So, when was the expungement? Has it been granted?
Mm-hmm. It has.
When was it filed?
Yesterday.
So you got it in one day?
No. It was filed over the weekend.
Okay, but she got the expungement that quickly.
Mm-hmm.
Any reason why this expungement wasn't done maybe February 4th?
We had discussed different things. I didn't think this is going to be prolonged. Well, I don't want to talk about what my client and I discussed because that's privilege. But clearly she had expressed interest in, wanting to get it expunged. How do I do that? What's going on? Because I don't want this out there. I don't want, now that people are running around town calling me a felon, I want it off my record so they can't keep doing that because it is defamatory. And now it's officially gone. They can't say any of that stuff, right? They should have never said it before because it's disgusting, right? If this woman scares you that much, you got to run around town calling her a felon. My God, we got a pretty weird society, right? So, yeah.
And final question. Mr. Bopp says this is all political ploy. This is trickery. He said this is a dirty, dirty trick.
Yeah, she was put on the ballot to confuse voters, the whole 9 yards.
Yeah.
I don't understand why he thinks voters are so stupid, right? They aren't. I mean, he's literally said that in every single thing, that voters are that dumb, they can't differentiate between two Wilsons. That's insulting to me as a voter, right? And I don't know. He's the first person that brought it up that I read that said it was trickery and political stuff. No, this is political. Doing this stuff knowing that she doesn't have a felony and you're trying to drag her through the mud, calling her a felon, having all these blogs, having people call from high places to try and get her out of, running, whatever. This has nothing to do with her. It has something to do with the other people that you're going after. And she's just caught in the crosshairs, unfortunately. And she's 7 months pregnant, right? Just sucks.
Now here's the final question. When you look at this whole election cycle right now, between what's been going on in Senate District 38, between this lawsuit, the doxing, what's been going on up in other parts, the whole Turning Point USA, filing primary challenges. Have you ever seen anything like this before in Indiana?
No, it is disgusting. This is new getting ginned up. This too shall pass, right? Just gonna take a matter of time. And this was about doing the right thing, right? Representing her is doing the right thing because it's always right to do the right thing. Not that I'm some highfalutin ivory tower person, you know that. But it's always right to help someone out. This is disgusting. You don't bully people that you don't want in an election because it's gonna be harder for you, or you don't throw a temper tantrum and start throwing money against someone because you don't like them, they didn't vote the way you did. I mean, it's just 5th grade. I mean, getting a fist fight on the court, lawn over nonsense, right? This is a democracy, right? We have a democratic republic, right? Or am I confused? I mean, did we change overnight or something? Did we?
Not yet.
I mean, I watched some Schoolhouse Rock last night for a presentation this week. I am just confused.
All right, thanks, Sam.
All right, thank you guys. Thank you for coming.